All right, lawyer talk. They don't teach you that in law school. I promise you they don't teach you that in law school. How do I know? Because I've got Troy right here, a law student, asking me questions about things that he has not been taught in law school. So if you're in law school or you're considering law school or you just like this kind of stuff, I guess a lot of people do, as it turns out, then tune in to this and all sorts of other great content that's coming out on lawyertalkpodcast.com. So you can go to lawyertalkpodcast.com and you can actually see where it's all broken down and you can pick the segment you like. We got questions and answers, we got breakdowns, we got interviews, we got all sorts. There's even a great archive of some of the old days of Lawyer Talk. Trust me, there's some great content if you go back and really are bored. But today this is another segment of the They Don't Teach You That in Law School. We just have Troy, Bella, our normal, or who has also participated in this. She's not here today. It is the holiday break, so even law students get a break. But not you. You're here working.
Yeah, no, I'm here full time now.
Yeah, full time. So, all right. So, what are they not teaching you that you want to know about today?
So we just talked about a little bit. The Daniel Penney case that's been all over the news.
So you already dropped it. We talked off the record or off the air about this. Anyway, so yeah, the Daniel Penney case.
Yeah, so the one thing that really stuck out to me in the whole case, politics side on it, was when the jury received it, what I was reading online and understood was that the charges got dropped and like recharged with lesser charges. That's how I was reading online. And
there's a lot of questions about this and what really happened. And, the defense was strenuously objecting to what happened. And even I raised my eyebrows, and I've tried lots and lots and lots of criminal cases, lots of murder cases. And it took me a minute to figure out exactly what was going on. But it looks like Penney was charged, and I actually printed, I've got the jury instruction here. We'll get to that. But Penney was charged with 2 different counts of homicide. One was a manslaughter, and a manslaughter in the second degree, whatever that means in New York. And usually manslaughter is as a result of committing some other crime, or you've got some justification that wasn't quite self-defense, but maybe you were acting in hot blood or pissed off. That's a traditional manslaughter. And Penney was also charged with a negligent homicide. Criminally negligent homicide. Mm-hmm. And negligent homicide would be a lapse of duty of care of some sort that would be a lesser type of homicide. So maybe we'll put it in terms that people can understand. Take it with a car. If I'm driving negligently, like I just run a red light mistakenly, I'm not even on my phone, I just blew it, I screwed up, I made a mistake, somebody died as a result, that would be a negligent homicide. If I am if I'm driving fast, if I'm the case in Ohio we just talked about recently, where a guy avoided a traffic control cop, disobeyed an order, and went around the line of traffic, ran into a firefighter or a first responder of some sort and killed the guy. All right, now you're starting to get to more reckless or even a manslaughter type charge, so it's more enhanced. So you can kill or you can commit homicide in different ways, and a lot of it has to do with what's up here in your head. And that's sort of the backdrop for the Penney problem. And the Penney problem was this. In the indictment, the people, the state of New York, opted to charge Penney with 2 different charges. One would be the manslaughter charge for murder, and another would be the negligent charge for murder. Now, there's different ways that prosecutors can go about this kind of problem. I've tried lots of murder cases where I've got a charge of aggravated murder here in Ohio, which means somebody acted on purpose, or maybe there's some enhancing circumstances. And then I've got lesser charges of murder in the same indictment. Okay. In Ohio, we go try that case, and the jury can render a verdict on any one or all those charges. Now, there are times where we get what we call inconsistent verdicts, where logically it doesn't make sense, where it's just so out of whack that it doesn't make any sense. Like, there's no way you could acquit on one charge but convict on another, and you might see that if in depending on how it's charged. That's a rabbit hole we don't need to go down, but it's complicated. In New York, apparently, here it's a little bit different. So, let me finish in Ohio. Now, if the prosecutor charges my client, say, with straight murder, and I go to trial, in the heat of battle, I'm arguing self-defense. We get to the point where the judge is going to instruct the jury on what the law is, on the elements of the offense. And the prosecutor and the defense often would stand up and say, "Judge, I want I am requesting that you instruct the jury, Your Honor, on something called a lesser included offense. A lesser included offense, generally speaking, now I get it, you technicians out there are going to say there's a lot more to it, because there is a lot more to it. But generally speaking, a lesser included offense means if you commit the bigger offense, the larger offense has all the same elements contained in it as the lesser, except it's missing one or two that make the bigger one the bigger one. Make sense?
Yeah.
So, if you've got it's just, there's more elements, enhancing elements that need to be proved, that the prosecutor has to prove, and those don't exist in the smaller one. So the jury, in theory, could say, look, we agree that there's a murder, we agree with all the other elements, but we don't think it was there were aggravating circumstances, or he did it on purpose. Instead, we think he did it with some lesser mental element. But that lesser offense encompasses that. That would be a lesser included offense.
Why don't prosecutors just always charge then the over offense and include the lesser offense?
Well, there's all sorts of strategy at play here. And this goes, we did an episode on grand juries and that at one point. So if you've just got a basic grand jury that you're going to have your complete hands off, sometimes you'll get charges like that. A grand jury will vote for, well, isn't there manslaughter? Well, you can vote on manslaughter if you want, and you can get this plethora of offenses in a single indictment. But why would the prosecutor not seek an indictment on a bunch of lessers? Why do you think?
He needs it as a negotiation tool, probably.
That's one reason, but probably not the primary reason.
Well, if it's a prosecutor, the lessers might be misdemeanors, and they don't have.
That's right. They want the guy convicted of the more serious offense.
Yeah.
And if they charge it in the indictment as a lesser, then they're running the risk of having a jury acquit on the primary offense and convict on the lesser. Now, that doesn't automatically mean the defense at the trial can't ask for the lesser, because the defense can ask for lesser included instructions as well. But sometimes what will happen is on these murder cases, they aren't theoretical lesser included offenses. So the definition, as we said, was the greater offense sort of encompasses the lesser offense. Sometimes it doesn't. Sometimes there's not a lesser. So in Ohio, just as a matter of law, negligent homicide is not a lesser included offense of murder. Murder is a felony of the first degree, the highest level felony. Negligent homicide is a misdemeanor. And long ago, the Ohio Supreme Court said, look, even though, I don't think they said it this way, but here I interpret it this way, even though clearly negligence is a lesser form of the mens rea, the purposeful murder, we're going to say it's not a lesser included offense, because they knew, the courts know that if you start instructing on negligent homicide, you're going to get murderers with convictions for misdemeanors, and nobody wanted that to happen.
I wish the Ohio Supreme Court wrote all their decisions like that. It's a lot simpler now.
Right. Look, I mean, you learn to read between the lines of what's really going on, and the policy behind that is obvious. They didn't want a bunch of murder cases resulting in acquittals on murder and convictions on negligent homicide, because, they're murders. So now if the prosecutor instead, and it looks like that may be what happened here in Penney, decided to include the lesser, even if it may not have been a complete technical lesser offense, or maybe under the nuances of New York law, it's just how they do it, in the indictment. So the prosecutor charged both in the indictment. But the judge instructs the jury as if it were a lesser included offense. Here's what I mean. The prosecutor, or the lesser included instruction goes something like this in a normal case. You, the jury, you should first take a peek and consider and look at the lead charge, murder, or whatever it is. And if you find that the prosecutor has proven the charge of murder beyond a reasonable doubt, then you're done. You don't need to consider the lesser included offense. But if you find that the prosecutor has not proven beyond a reasonable doubt the charge of murder, then you should consider the lesser included offense of reckless homicide, involuntary manslaughter, whatever it is. And then it gets even more complicated, as it did in Penney, when you add self-defense into the mix. So the prosecutor in that case in New York, the prosecutor had to disprove self-defense beyond a reasonable doubt. So Penney clearly had a self-defense claim. The prosecutor's job was not only to prove the elements of murder or manslaughter, they had to disprove that it was self-defense. Now, look, and I'll read this just because if you're on a jury, it sort of exemplifies how impossible this is to figure this out unless you have like a chart. But if you find the defendant guilty of count 1, manslaughter in the second degree, then do not consider and do not render a verdict on count 2, criminally negligent homicide. Simple enough. That's what we just talked about. Yeah. But here's where it gets complicated. If you find the defendant not guilty of count 1, manslaughter in the second degree, for the reason that the people have not failed to prove beyond a reasonable doubt that defendant was not justified, then you must not consider count 2, criminally negligent homicide, and you must also find the defendant not guilty of that count. If you find the defendant not guilty of count 1, manslaughter in the second degree, for some reason other than the lack of justification, then proceed to consider and render a verdict on count 2, criminally negligent homicide. I confess, I know what they're trying to do here. I had to read this like 3 times to get it all figured out.
It is kind of hard.
Because they're using double negatives. And that's just, look, lawyers suck at explaining stuff in common terms. And one of my mottos, as I say all the time, upstairs, downstairs, podcast in the real world, is I like to make things simple. Almost everything can be made simple, and that's what we're going to do right here. What they're saying is, if you find Penney guilty of manslaughter, you're done. You don't need to do anything else. All right? If you find defendant not guilty of manslaughter for any reason other than self-defense, then you got to go to count 2, the negligent homicide, and consider that one. If you find defendant Penney not guilty because of self-defense, you're done, because the self-defense claim would apply to both. Right? That's sort of what's happening here. Now, why the controversy?
I think the controversy, at least from my perspective, maybe this is just like a law student view, is during jury deliberation, you drop the more serious charge. It almost seems like what I would interpret as like an unethical play by the prosecutor to try and sway the jury into, hey, I took out the hard one. Give me the softball here. Like, why not? That's how I viewed it initially.
Yeah, that's right. So you were asking initially, why would the defense or why would the prosecutor not want lesser included offenses? So we're going to answer this, but let's sort of give some real world examples first. I had a murder case, and I had a client who was surrounded by 3 people outside a bar on the west side of Columbus, the kind of bar where you certainly don't want your son, daughter, whoever hanging out at. It was a roughneck bar. And my client found himself surrounded by 3 people based on something that happened in the bar. I'm not going to go into detail. I think 2 of them had tire irons and one of them had something else. Nobody had guns or knives other than my client, who had in his pocket a knife. And one of those kind that has a little hole in it so you can flip it up with your thumb.
Switchblade.
It wasn't a switchblade, but it had a hole on the blade. So it was a little 2-inch blade. Okay. It had a hole in the blade that gave his thumb enough friction where you could flip it open with just your thumb and have it. So he pulls that out of his pocket, flips it open. And, as he's sort of fending off these 3 people, he stabs 2 of them. One of them he got right there in the rib cage because he's holding a knife like that. And that is just a little short blade. But that resulted in the blade went right through the rib cage, pierced the pericardial sac of the poor victim's heart. And the pericardial sac, which is his membrane that surrounds the heart, that fills up with blood. And I think it's a condition. I'm not a doctor, but I think it's a condition called pericardial tamponade, which means it fills up the membrane, the sac around your heart with blood, and your heart can't pump.
For not being a doctor, I feel like you did pretty good there.
I've heard that testimony a few times because there's lots of homicide cases that happen that way.
Oh, okay.
And the guy died. All right. So now my client's accused of murder, straight aggravated murder or straight murder. So acted purposely, tried to kill, the whole 9 yards. And that was back in the day in Ohio where I actually had to prove self-defense. The prosecutor didn't have to disprove it. I had to prove it. So fast forward, we get to the point where we're talking about these kind of jury instructions. And my client in the indictment, the prosecutor did not charge any of these lesser offenses. And I had to look at my client and say, listen, do you want me to ask for a lesser included offense of manslaughter, of involuntary manslaughter? And he just kept asking me the same question. You think it's more likely I'd be convicted of involuntary manslaughter? And I kept saying yes. And he goes, well, then no. And I was like, I don't think you understand my question. But he did understand. And what he was saying is, I want to walk away free. Mm-hmm. I don't want to risk. I think it's more likely that the jury will say not guilty of murder and just land on manslaughter because they want to convict me of something. And it's sort of what you were saying. They're going to convict me of something, so we'll give them something other than the bait. We'll give them different. We'll give them a little something less to bite on, so they don't have to feel like they're really, really smacking the guy. So my client says, no chance. He had balls of brass. Staring at 15 to life in Ohio versus something less than 10 years if he's convicted of the lesser charge. Fortunately for him, it worked out. After the same kind of thing, after like 5-6 days of jury deliberation, the jury comes back with an acquittal, and my guy is found not guilty. Here's what happened in Penney.
Well, let's circle back to your case here. What if the prosecutor wanted to jump in and add lesser offenses then? maybe the prosecutor was scared. They're deliberating for 5 days.
But he wanted the whole shoot match.
Okay.
So, the prosecutor in theory could ask for lesser included offenses, but he wanted the whole shoot match too. So it was like, here we are, fight for the death. It's all or nothing. And these kind of strategy calls, they certainly don't teach you that crap in law school. And I can attest, that was back in the 90s. That was one of my first murder cases. And I can attest what that did for my level of anxiety, my ability to sleep. These are hard strategic decisions that we as lawyers, particularly criminal defense lawyers, trial lawyers, we just learn to live with. I mean, we all the time we're making these huge decisions that, and as you probably heard me say upstairs, there's no right answer. There's only crappy and crappier, and that's how I look at it. That is honestly how I assess decisions like this. Like, look, client, there's no good answer here, because good implies that there's a good answer. Like, there's a great there is a path through it no matter what. In situations like that, there's no good answer. There's only the best answer, and at best doesn't even describe it. There's only crappy, and then there's levels of crappy. So let's choose the least crappy answer, and that way we're not calling it something other than what it is, a really crappy situation, right? Because I think it's a misnomer to have any sort of credibility with your client if you act like something is good. And I get it; these are semantics, but it matters. I think, if I'm sitting in my client's shoes, I don't want to hear that there's a good answer, because there's no good answer, only a crappy one. But I want the least crappy. I'll choose that every time if my only options are crappy. So anyway, that's a little aside. Back to Penney. Or did you have more on that?
No.
Okay,
so back to Penney.
So back to Penney. What the jury instructions are doing here is basically mimicking the scenario I talked about, where the judge in the middle or at the end of the trial offers a lesser included offense, except the prosecutor has included the lesser in the indictment. And the judge has instructed the jury, you don't even get to the lesser included offense until you've decided the primary offense one way or another. But there's a problem. The jury couldn't decide the primary offense. They hung. They couldn't reach a verdict. After a week of deliberation, give or take, they come back, the jury comes back and says, Judge, we can't decide. We got a hung jury there. And I think later on we found there was like a single holdout. I'm not sure. Mm-hmm. So it's like 11-1, one way or another. And we can't get a consensus at least in New York and Ohio. There's got to be a unanimous verdict on criminal offenses, right? So you got to get 12-0 one way or another. Anything short of that, you got a hung jury. Now, that has all sorts of ramifications of its own. If I'm on the defense, I'm thinking, all right, well, I get to at least live to fight another day if I've got a hung jury. And then later on, we'll interview the jurors if they'll talk to us and figure out what the split is. Sometimes the judge will ask, even on the record. But yeah, we got a hung jury. Now, there's another thing I don't know if they will teach you this in law school, but there is we call it a dynamite charge. In Ohio, it's a case called Howard. I can't remember what the U.S. case is off the top of my head. But the judge will say, look, your job is to reach a verdict. So here's how it works. The jury comes back and says, Judge, we just can't decide. We're deadlocked. We don't think with even the most intense deliberations, we're ever going to get a decision. Typically, the judge will give them the dynamite charge, which you can look it up. But it basically says, your job is to decide this. You should decide this. You should not think that any other juror is going to be in a better situation to decide this. It's on you. Do your damn job. Shut up. Go back, deliberate, and come back here and give us a damn decision, or else. It's sort of like that. Mm-hmm. Some lawyers love them. Some lawyers hate them. I'm hot and cold on it. I've been, maybe it just depends on how I feel about the case at the time. But here, presumably the judge gave that instruction, and the jury still comes back and says, sorry, we can't come up with a decision on this one. Now, what to do? Here's where your comment comes in, because the judge has just told the jury, you don't get to look at count 2 until you render a verdict on count 1. And now the prosecutor says, well, we're just going to do an end around that problem, and we're going to dismiss count 1. Judge, we ask you to dismiss count 1. In other words, we don't even want the jury to consider count 1. We're going to change the rules in the middle of the game, and now we just want the jury to consider count 2. And you can obviously understand why, because the prosecutor, well, you tell me, but we'll play it Socratically.
So the prosecutor wants to get something, so count 2, the only way you can get to it is by tossing out count one.
Right.
And I just think it looks a little bad, but honestly, the jury instructions I think are bad.
Well, the jury instructions at least, look, they aren't the most artfully written prose, but at least make sense. If I would have explained it, if I were arguing the case in front of the jury, I would have said it this way. All right, folks, this is a bunch of mumbo jumbo. Here's what's really going on. You got to look first at count one. This is the manslaughter. And if they don't prove manslaughter, just on the face of it, the verdict's not guilty. And only then can you go to count two, the negligent homicide. But if you find that they prove the case and the defendant, my guy, Mr. Penney here, acted in self-defense, which, by the way, he did, then you're done too. So the self-defense applies to both. And if he's acting in self-defense on count one, it's a foregone conclusion that he's acting in self-defense on count two. Now, if you just think he didn't commit count one for some reason, only then do you get to go to count two. Now, look, we don't carry the way because he acted in self-defense either way. Now, the prosecutor's thinking, as you said, well, look, it's like my client. He's more likely to get convicted of count two because it sounds better. It's less. It's a lesser charge. And the jury's going to know that, so they're going to throw us a bone. And, and then he's also thinking, I think they knew, sometimes the judge will ask, what's the split back there? You guys 6-6, 10-1, 10-2, 12 or 11-1, whatever it is. So the prosecutor's thinking, well, I'll probably get at this point a verdict of guilty on count two. And I agreed. When I saw that going down, I was like ballistic. I'm thinking, man, I would be having a tantrum in the courtroom if a judge did this. This is the prosecutor and the judge basically changed the rules in the middle of the game.
Defense did object to it.
They objected, yeah. And I've never had this happen. And mostly because I've generally in Ohio where I try murder cases, this wouldn't line up this way, right? We would just get it just wouldn't happen. Now, and if it did happen, if the prosecutor did elect to dismiss on the hung count, then the jury was not permitted under state law to get to the second account until they considered the first, I'd be like, look, this is paramount or tantamount. So paramount and tantamount. You ever look those words up?
No.
All right. So paramount means
I see on the
more.
TV a lot.
Tantamount means the same. So this is the same as a hung jury on both. Logically speaking, if the jury can't consider count two until they get a decision on count one, then a hung jury on count one by definition means they don't have a decision on count one and they never get to count two. This is a mistrial for a hung jury. Judge says, well, I'm going to let it happen, see what happens. I'm going to do it.
The reason I thought it was kind of unethical was, in my head, a prosecutor will only prosecute a case if they believe beyond a reasonable doubt that they can convict this guy based on all the evidence that they have. And if you want to dismiss it, that means you're like, never mind, I do have some doubts as the prosecutor, which means the jurors should. So in my head, the minute they finish their case, if the state really wanted to dismiss it, the minute they finished presenting their case and they had doubts, they're like, wow, we should dismiss it now. We should have done it from the beginning. Instead, you wait till the jury has it, till in theory the defense presents their case, which is self-defense. I didn't really pay attention too much to this trial. I don't know if Penney took the stand or not or anything like that.
Well, look, here's what you're getting at. The prosecutor's job, in theory, is to do justice, not win. It's to leave out the prosecutor should leave out his or her personal emotional attachment to a case. Here's the problem. We're all human. And we all have personal attachments to almost everything, particularly in something like a criminal murder trial where it is adversarial by its nature. So we have created a system where it's adversarial by its nature. It even says that. We love it. And if you read U.S. Supreme Court, like classic case law on this, they talk about the clashing of ideas and only then can you reach the truth, and cross-examination being the greatest legal engine ever discovered or ever invented for the discovery of the truth. You know what? Like, we talk about that stuff as if it's a good thing. And then at the same time, we expect prosecutors to be, to step higher above it and do justice. It's very difficult for prosecutors to do it. Look, I'm not giving you prosecutors a break, but I am empathizing, I guess, on some level. It's like, look, we expect you to go fight in a courtroom, and at the same time, you have to do things that hurt your case. The prosecutor's job is to give the defense the good stuff. So, hey, here's evidence that helps you. I didn't have it before, but now I have it, and sort of slip you the trump card under the table. The prosecutor's job is to do that. At the same time, it's to win. So it's like, you can see how these dilemmas happen. Add into the milkshake things like, politics. There's a lot of racial debate. I'm not going to go into whether I agree or disagree with it, but like add those things into it, and add into it like the prosecutor's voting constituency. What does the prosecutor think his voters want? It's like add all that stuff into it, and it gets hard. So I agree with you. The prosecutor makes a decision here to say, not what's just, but I want to win the damn case. And I think it's more likely that I get this guy convicted of a lesser charge. I think that this violated the law. I think this violated the law in the sense that it would have been a due process violation, an unfair trial for the judge to dismiss the lead account or the lead count, the lead charge on the indictment, only so the prosecutor could get a verdict on the second charge when there's been this sort of the rule of the case up to that time was that the jury never considers the second charge until they actually decide the first. So the judge changed the rules of play. If I had been arguing for the defense, I'd say, you changed the rules on me, Judge. I tried this case with this in mind. Now you've changed the rules on me. If these folks wanted it to be a negligent homicide, they should have indicted it that way and that way alone, or they should have indicted it differently. I don't know the rules of New York on how that works, but in this jury instruction, they never got to count 2 until count 1 was done. So I agree. Now it turns out somehow the last guy, so think about this for a second. You've got somebody holding out on count 1, and I think it was, I don't know if it was 11-1 or one way or another, but the same person on count 2 was willing to go along with the crowd. So I don't know what happened. As my dad used to say, the Holy Ghost descends upon the jury room once the case is over, because juries tend to get it right. They tend to get it right. Now, again, this is contrary to the pulpit and the table pounding that's going on now on both sides of it. But I think the jury got it right. So the question here is, did the prosecutor disprove self-defense beyond a reasonable doubt? Clearly not. Clearly not. Was justice done? Well, I'll let you guys figure that out. So
12 people heard it best.
12 people. That's right. All right. Well, this has been, they don't teach you that in law school. And I can, trust me, they don't teach you this in law school. I had to figure, like, this took some, this is sort of like 300 level stuff. And most people don't get to that in the realm of criminal defense. And even the news, when I read the news commentary on this, most of the time they don't understand the nuance of what's really going on. So these are great questions. If you've got your own question, by the way, it's easy. Just go to lawyertalkpodcast.com. If you've got a topic that they're not teaching you in law school or even college or even in your own life, you can just submit the question there at Lawyer Talk Podcast. Go to the socials. Troy's keeping us up on that. Leave a comment. There was a comment I'll get to on another thing we did. But at any rate, check us out, lawyertalkpodcast.com, off the record, on the air with They Don't Teach You That in Law School, at least until now. Hey, Steve Palmer here from Lawyer Talk. Thanks for listening. Hope you enjoyed it. Check us out, all our social media. Like, share, interact, ask your own questions. We're here for you.